Senator Rothfuss,
Excused.
Senator Wasserberger,
Excused.
Chairman Anderson.
Here. So we have a quorum?
You have a quorum, sir.
All right, we have a quorum, so we'll get going. Welcome to the Minerals Committee meeting. Today, we have a lot of rules you got to live by, and we'll make sure you do. And so the bills we're going to hear today is House Bill 102, Wyoming Preference Act of 1971 amendments. And I've got a list of names of people that are on this. Is there anyone here who'd like to present that bill? You want?
Chairman,
Yeah.
Eric Barlow did present it at the last committee meeting, but I'm happy to do a recap of it.
Okay, you want to do a recap? Yeah, I think we had Barlow and Legursky and Ryman. Yes.
Just a continuation for last meeting.
Yeah, this is more like a continuation than an introduction, because we've been through most of this. So go ahead, Katie.
Thank you, Mr. Chairman. I'm Katie Legursky with the Associated General Contractors, and with me is Lauren Benford with Ryman Corp., Kenny McKillop with DRM, and also on Zoom, we have Emily Benton with Keyhole Technologies. And if you would like, Mr. Chairman, I can just do a quick little recap of this. What this bill is, it's making amendments to Wyoming Preference Act of 1971, otherwise known as Labor Preference for Contractors. Right now, contractors are required to use as many in-state resident laborers as absolutely possible on their projects. This makes a few slight changes to the current statutes. And just very quickly on page 2, it just updates the wording from resident to Wyoming labor. And then it gets into the meat of it, where instead of having the non-resident labor or to qualify as a resident labor, at least 1 year residency immediately preceding becoming to work for a contractor, changing that to 90 days, which was amended in the House. And then the proof of residency in the state of Wyoming shall be established through the following evidence that's listed before. At the previous committee, we did have some discussions on whether that section to show their proof of residency is necessary or not. Then the next section on page 3, 16.6.203 is going into the meat of it, that says that contractors in the state of Wyoming providing public works contracts must contact the Department of Workforce Services if they're in need of any laborers 10 days prior to when they need these individuals. So they contact the Department of Workforce Services with their needs for the projects coming up. The Department of Workforce Service has 10 days to get back to the contractor whether there's resident laborers available. If not, they issue a certificate to the contractor to be able to hire the non-resident. This change it currently right now, it must be done by project to project. This section here changes it that it can be done for the construction season so that contractors are able to move that non-resident from project to project to projects. On page 5, it talks about the emergency type projects. There are occasions where we have a water line break, we have a landslide, some other type where we need emergency employees to come work for us. So this gives us an emergency clause and has the Department of Workforce Services respond back to us within 3 days. And then the last portion, which is strictly the meat of it, is the failure for a contractor to apply with this. In this section, we are just changing, again, public works project to a public work. One of the things I will stress, the penalties for violating this are extremely high, in that a contractor can be barred from bidding on any public works projects. So this is something that, we pay very close attention to. So we just wanted to make a few slight changes to the labor preference in order to make it a little more user-friendly for our contractors. And with that, Mr. Chairman, I'd stand for any questions.
Any questions for Ms. Legursky?
Mr. Chairman,
Senator Cooper.
Mr. Gerke, the I just wonder if this time requirements here is going to put undue restrictions on the contractor when he's not able to find help. A 10-day lapse is, if he's shut down waiting on help and there's help available, that puts the contractor in a pretty tough situation. He's losing money every day. Is there provisions in here that I'm not seeing for that?
Mr. Chairman and Senator Cooper, the one really nice thing about that, if we do get into that situation, we are able to move another if this bill were to pass, we're able to move a non-resident from another project to that project, because instead of talking project by project, we're talking a 9-month period where we have a little more flexibility to move our employees from project to project, and going from a year residency requirement down to a 90-day residency requirement helps us dramatically. So a lot of those circumstances, yeah, it does cost us time, it does cost us money, but with these slight changes, it should alleviate some of those. And the 10 days, it's pretty a lot of times the Department of Workforce Services will get back to us before that 10-day time period. And they're very good to work with on the emergency type situation. So this will definitely help us in addressing that very same issue.
Thank you.
Other questions for Ms. Gursky? Other questions? Hearing none. Thank you, Ms. Gursky.
Thank you.
Bringing us back to the bill. You want to go ahead?
Sure. Thank you, Mr. Chairman. Lauren Benford. I work for Ryman Corp here in Cheyenne. We do highway work and commercial work. So we do vertical and horizontal. Just wanted to say we do try and hire local. We want to hire local. That's our first and foremost goal. And then maybe a little clarification on the hiring for us. We're in our hiring season right now because our work, once the weather goes, we're full blown for the next 9 to 12 months, however long we can go. And so if we end up having to hire someone who is not a local, we would actually get the certification on that person now. So then when we're moving forward, we don't have the issue of trying to juggle that person because they can't go to a public works project. The things that I think are super important as a contractor, our goal is to be on time, on budget, and number one is safety for our employees. And we find a lot of times when we're mixing our crews around because they're not capable of going to that project, it's not a unified team anymore. And so we spend a lot of money on training. We spend a lot of money on making sure that we have this unity in the beginning of the year, and the ability to have someone certified because they are out of state early and just move them all year long. We're hoping is a benefit for our crews, because right now we're seeing it being kind of detrimental when we're not fluent throughout the year. So that's kind of where we're hoping that this allows us to work through. One other thing, I know someone had mentioned about there are certain skills we don't have in this state. As a flat work contractor, if we have a subcontractor we don't have that needs to do some type of finishing on our contract, those contractors don't exist. So when we bring them on, it would just be nice to say we have 10 projects that need this sub and get them certified to just keep going all year long instead of having to break it up. So it really gives us the fluidity throughout the year once we get moving.
Lauren, can you give me your last name once again?
Benford, BENFORD.
Okay, thank you.
Thank you.
And you, sir?
Thank you, Chairman. I'm Kenny McKillop with DRM. I guess most of my points are already covered. The big thing that this does for my company is where probably 85 to 90% of our work is public works work. So we have can crews and we have cannot crews, and we have to keep that separation. And the can crews can work on public works and the cannots obviously cannot. And being in the northeast corner of the state, a lot of our recruitment comes out of Montana or South Dakota for the higher skilled positions. And it's awfully tough as a contractor to recruit somebody to Wyoming and get them to move their family here and then be limited on where I can use them. And so with this, with this change in having the certificate follow the employee, if you will, rather than the project, gives us that fluidity to recruit better, I guess, if you'd say. I think other than that, I think it's pretty straightforward. We're certainly not against it. We would always prefer to hire local first. And really we're dealing with the exception of the rule, not dealing with the anomalies, not the mass. So I guess with that, that's all I got.
All right. What was your first name?
Kenny, Kenny.
Oh, Kenny. I thought you were saying Jenny. But that's a
I'll-
little unusual.
I'll answer to that too if you'd like.
Okay, Jenny. Okay. Any questions for Mr. Phillips? Any questions for Mr. Phillips? Mr. Phillips, is Dan McKillop still involved with your organization?
He is. He's my grandpa.
Oh, he is.
He is.
Oh, I'll be darned.
Yeah. So I'm part of the third generation. We have 4 generations active in the company right now.
Oh, I was in Gillette, 35 years ago when he was just getting started.
Oh yeah.
He was a lot of fun. He was a lot of fun, that guy.
Oh yeah. He's still there.
Oh, good.
Still in the corner office. So.
Yeah, good. He's a good guy. Any other public comment? Any other public comment? I think you said you had a couple on the virtual.
Yeah, Mr. Chairman, you have 3 people who would like to testify virtually. We have Miss Emily Benton, Mr. Wolf, and Miss Mansfield, Mr. Mansfield. So if those attendees would please turn their video on to be called on by Chairman Anderson, that would be preferred, please.
Let's take Emily Bennett first, since I've got her written down already.
Thank you, Mr. Chairman. My name's Emily Benton. I'm with Keyhole Technologies out of Casper, Wyoming. We are a traffic control company that operate all around the state. A few things that I wanted to touch on in regards to this. In our normal construction season, we could potentially hire between 200 and 250. Most of the people that we do hire come either are new hires or very few of them are returning. We have kind of hit some barriers with the fact of having to have a lot of these people be residents. Some of the places that we need to go hire may be pretty remote locations, and it gets really difficult in a sense. We've had to deal with preference here and there through various projects throughout the years. We're a bit different than the other 2 that talked about how they have crews that can move from project to project. In our industry, we can't really necessarily share some of those people. If we do end up hiring non-residents, we get pretty stuck with having them stay in a specific location. And then when we're done with them on that job, we can't really utilize them as an employee. A lot of our help tends to be seasonal, with the construction industry being seasonal. So sometimes we get to bring in college kids to work for us, which gives them a good summer job. It gives us the temporary help that we do need. But we also kind of hit barriers on hiring college kids because a lot of them tend not to be residents or coming from out of state. So it would really benefit us in ways to be able to loosen the requirements of the 12 months to the 90 days. That is pretty much all that I have. I'm happy to answer any questions if you do have them.
And it was Miss Bennett?
Benton,
Benton, excuse me.
Benton.
Any questions for Miss Benton? Any questions? Any questions? So I'm assuming you like this bill because it changes it to a 90-day measure.
Mr. Chairman, I think it would be a lot easier for us to seek out using those non-resident workers if they've only been here for 90 days. It very much so would make it easier for us to employ them, and especially if they could move from project to project. We're kind of different in the sense that we normally don't hire non-residents. We do require them to have Wyoming driver's licenses. And so I kind of stress on my employees. I'm like, you can use them on this one, but you can't share. They have to stay here. That's the only place that they are allowed to be. So it would help the other employees in sharing and making more unity, like the two testifiers before me said.
Other questions for Ms. Benton? Other questions? None? Thank you, Ms. Benton, for your testimony. Who's next?
Thank you very much.
Mr. Chairman, Jason Wolf with Department of Workforce Services. Trevor Mansfield and I are both with the agency, and we just wanted to be available for any questions that might arise. But I think Ms. Legursky and the testimony already kind of really laid out the bill well, and was able to show the benefits of it. And it will be a workable solution for our agency. It does simplify some processes for us as well. So. But would stand for any questions. Thank you, Mr. Chairman.
Okay, any questions for the Workforce Services? Yes, Mr. Cooper, Senator Cooper, excuse me.
And thank you, Mr. Chairman. Gentlemen, I'm not sure exactly how this is going to apply directly to this bill, but we run into a lot of times after we've really gone through our unemployment group, if you will, the people that are seeking, we run into people that we consider unemployable for whatever reason. Maybe they don't pass a drug test. Maybe they've been dismissed by this company at some point in the past for whatever reason. Would that person, even though he's a resident, still have preference? Does he still have preference over an out-of-state employee?
Mr. Chairman?
Yes, Mr. Wolf.
Senator Cooper, yeah, if I understand the question correctly, as long as, the labor that we're looking for instance, if it was, an electrician or something that was needed by a contractor, if that person held the qualifications to fulfill the job and was a Wyoming resident, yes, they would still have preference.
Follow up, Mr. Cooper? Senator Cooper? No? Other questions? Other questions? Hearing none, thank you to the Workforce Services team. Anyone else? Is there anyone else on the tube? No?
Mr. Chairman, you had Mr. Mansfield. Did you want to testify, Mr. Mansfield?
Mr. Chairman, I was just here with Mr. Wolf to assist with any questions for the Department of Workforce Services.
Well, you've done a good job. All right, then we'll close public testimony and committee, what's your pleasure?
Second.
Moved by Cooper and seconded by Beitman. Any changes, alterations?
Mr. Chairman?
Yes, Senator Cooper, Senator Rothfuss.
Thanks, Mr. Chairman. We talked at the last meeting about some concerns I had with how the proof of residency ends up working out, being probably overly exclusive. And in discussions afterwards, there was a general sense that just removing the provisions on page 2 onto line 3 and in the beginning of the paragraph probably takes care of that problem, and then it would just be done through rule and regulation. So I'm going to move to strike it and amend slightly. My motion then will begin on line 8 of page 2. Strike all new language from proof of residency.
Proof of residency to the end of the,
Yep,
End of the paragraph?
strike the rest of the page.
oh, the rest of the page?
Yep, strike the rest of the page.
Oh, okay.
And then on to page 3, strike paragraph D, strike paragraph E. And before the end of the sentence, so going back to line 8, I'm going to insert just a little bit of language if I can. So it reads right now, for at least 90 days preceding the application for employment, I would include in my motion inserting before the end of the sentence, or as otherwise authorized by rule of the Department of Workforce Services, or as otherwise authorized by rule of the Department of Workforce Services.
And where are you? I'm,
Yep, no worries, Mr. Chairman. On page 2,
Right.
line 8. It says application for employment period. Before the period, I would be inserting that language. Or as otherwise authorized by rule of the Department of Workforce Services. Mr. Chairman, the intent there is actually the summer workers that were mentioned, where I'm imagining a circumstance where you've got a kid who's a Wyoming kid, but goes to a school out of state, comes back in the summer, has to wait 90 days of the summer before they can actually get their little summer job on one of these projects because they haven't resided in Wyoming for the previous 90 days. It seems like that's exactly the kind of thing that the workforce services folks could sort out if we let them. And there might be other uses, but that's really what I'm shooting for, is those kids that are residents of Wyoming. They grew up in Wyoming, but for whatever reason, they haven't lived 90 consecutive days in Wyoming prior to the summer. That's my motion.
would you restate that as otherwise ruled?
Or as otherwise authorized by rule of the Department of Workforce Services. That language is actually on page 3, line 9.
Senator Rothfuss, could you also go back over the paragraphs you wanted deleted?
If there's a second. Is there a second? All right, then yes, I
Seconded
will. So, Mr. Chairman, for
Yes.
clarity then, I'll start on page 2, line 8. Application for employment, and then before the period, or as otherwise authorized by rule of the Department of Workforce Services, period. And then strike all new language for the rest of the page. And then on page 3, strike paragraphs D and E, so lines 1 through 10. And that's the amendment.
You got it, Mike?
Yes, but you are keeping 11 forward. on-
Mr.
on
Chairman, that's correct.
Page 3.
Yep.
Okay.
That is correct.
Okay, any comments? Any
Thank you.
discussion on this amendment?
I have a question. Mr.
Yep.
Chairman.
Senator Bateman.
Question on the amendment. So are we giving by adopting this language, would we be giving the Department of Workforce Services the authority to allow non-citizens the ability to do this? That's the way I'm reading it, in the way it's currently written in the language.
Mr. Chairman, I see why Senator Biden's saying that. The honest answer is I don't know. The construction of the sentence is a little bit ambiguous in that we've got a new and clause. And has resided, this is a new and clause, right? So you've got an or statement above, we've got an and clause. And then with the and clause, we typically in our construction then go everything after the and has to be true, and then you've got an or statement afterwards. So and has resided in the state of Wyoming for at least 90 days preceding the application for employment, or as otherwise authorized by rule.
I understand that, yeah.
So I think it's still okay. We could check.
I think it's okay. We can fix it if not.
Okay.
Other questions, other comments? Okay, all in favor of Senator Rothfuss amendment to whatever this bill is,
102.
102? 102. House Bill 102. Signify by saying aye.
Aye.
All opposed, same sign. Hearing none, he squeaked by. Anybody else got a change? Anyone else have any changes or additions or corrections? Hearing none, Mike, read the roll call, please.
House Bill 102, Senator Bateman,
Aye.
Senator Cooper,
Aye.
Senator Rothfuss,
Aye.
Senator Wasserberger,
Excused.
Chairman Anderson.
Aye.
4 ayes, 1 excused. Do pass amended.
House Bill 102 passes Senate Minerals Committee. Next bill to come before us is House Bill 207, coal-fired generation facility closures, litigation funding. And I've had a massive amount of people want to present on this. And Senator Beitman, are you wanting to open it up?
We got Representative Haroldson right here.
Oh, okay.
He's
All
the
right.
whole
He gonna do
lead
it?
Sponsor. He's gonna bring us.
Oh, okay. All right.
Thank you, Mr. Chairman and committee. Thank you for letting me come today. And I won't take much of your time. We can kind of dive through this. But before we do, I'm going to give a little bit of a background as to where this conversation started and where we kind of came up with an idea.
What's your name?
Sorry, yes, Representative Jeremy Haroldson, House District 4. So House District 4, inside of House District 4, we have a coal-fired power plant. And we can use proper names in here, can we not?
No. Ken?
Okay, so Laramie
Do
River
it.
Station resides in House District 4, and Laramie River Station is a 3-unit coal-fired generating power plant, partially owned by Tri-State Energy. Tri-State Energy is obviously a multi-state cooperative, and in 2019, we had a state of Colorado legislative move where in House Bill 1261 and Senate Bill 236, we actually had a renewable energy portfolio put forward by the state, oh, that was me, by the state of Colorado on all of their energy cooperatives, stating that they had to produce 80% renewables by 2035. And with that, that would require Tri-State to offload coal-fired generation. Now, one of the proposed offloads was by 2033 to take LRS Unit 3 offline. That would have obviously a direct impact on my representation and the constituents in my representation, as well as my community. And so I was sitting in a Tri-State WILEC board meeting a couple of months back, directly after our Texas power incident. And they were saying, you know, the problem is reliability is at stake here. We can't hold an 80% renewable portfolio with current technology. And this isn't a wind or solar battle we're talking about. This is a power technology issue that we're having a problem with, where if we don't have a way to produce reliable energy, then we are finding ourselves in a place where we're going to see lives potentially lost. And so out of that came House Bill 207. So the whole concept behind this bill would be to give the executive branch of the state of Wyoming the ability through, after amendments, $500,000 to pursue protection of Commerce Clause. And you might ask the question, is this something that can be done? Is this something that we have precedence? In 2011, we had a North Dakota versus the state of Minnesota lawsuit where North Dakota, who was put under a similar renewable portfolio, stood up against the state of Minnesota and said, hey, that's a breach of our Commerce Clause. It's an overstep of bounds. You can't do that to our cooperatives. And that actually held up in a federal court. It wasn't Supreme Court, but it held up. It was repealed. It held up a second time. And so there is precedence for states being able to protect their economy and commerce through this type of an act. And so this would give the executive branch $500,000 to protect this state against any other state that would breach Commerce Clause, in this situation, the state of Colorado. So the thing that I think we need to, just to bring it all back around, something we definitely need to understand is if we're not careful, these renewable portfolios are kind of in a way, just a dart on a board. It's a shot in the dark. And I think the nature of it is good. They want to have the cleanest power possible. But if we don't have technology capable of protecting our grid's reliability, then at this point, what we're doing is we're removing kind of the workhorses off the line, which also really affects our economy. But as we remove these workhorses, we're also taking and putting lives in danger. And so this bill would roll back, or this bill would potentially give us the ability as the state of Wyoming to say, hey, hold on, let's get some more technology in place. Let's figure out carbon capture and these types of things so we can produce clean, effective power that's going to bring generation to the Front Range that's going to help make sure that we have a reliable power grid and do it in a way that's intelligent. And with that, I stand for any questions.
Any questions for Representative Haroldson? Any questions? Yeah, Senator Cooper.
Thank you, Mr. Chairman. I just want, I understand myself, but I want for clarity for a question that was asked of me. This does not forbid power companies from closing the plants. This simply gives the governor or the AG funds to litigate that. Is that correct, sir?
Mr. Chairman?
Yes. Mr.
Senator Cooper, thank you so much. No, this is not putting any requirements upon anything. This is just simply saying, you know, if we have a coal-fired generating facility that still has life to run, we won't make you shut it down. If this were to go through, we won't hold you to another state's energy portfolio. This is just simply saying, you know what, we're going to give an arrow in the quiver of the governor to say, you know what, you can actually stand up for this state and make a dent. And it kind of, this is us as the legislature saying, hey, we stand behind you and we'll partner with you in making sure that we protect this state.
Any other questions? Any other questions? Thank you, Mr. Haroldson. Good job.
Thank you very much, Mr. Chairman. Committee.
Anyone else in the audience would like to speak?
Afternoon, Mr. Chairman and members of the committee. Sean Taylor, Executive Director of the Wyoming Rural Electric Association, in support of the bill. And I apologize, I got here a little late for Representative Haroldsson's explanation. So if I'm repeating something, I apologize. But part of this came out, part of the reason for this bill came out of a meeting that one of my cooperatives had with Representative Haroldson and a few other legislators, and our generation and transmission cooperative, Tri-State, G&T, out of Colorado. And the folks at Tri-State were explaining some of the laws and regulations that have been passed down in Colorado that forced them to be a little bit more regulated under the Colorado PUC. They had to submit an energy resource plan. In that plan, there's a bunch of modeling that happens, and they had to submit that. They had to submit their preferred plan to the PUC. And in that modeling, one thing that Tri-State mentioned was that in a year further out, I want to say maybe 2035, in order to meet Colorado's CO2 reduction law, which is 80% reduction by 20 something. I forget all my dates. I apologize. But in order to meet that,
Apology accepted.
Tri-State may have to curtail the amount of power that they take from Laramie River Station outside of Wheatland. And because they could not export that or import that into Colorado under that law. And so we sat back and said, well, that's Colorado having an impact on a Wyoming resource. Can we do something about that? And so that's why that's one of the reasons you have this bill before you. I mean, the coal port was another example, but so that's my support for the bill, Mr. Chairman.
Any questions for Mr. Taylor? Any questions? I have one. Is that the only state that we have a problem with that won't accept our electrons?
Mr. Chairman, it's kind of hard to say. I mean, California's passed a bunch of laws that, you know, we can't send our coal power into California. Washington, Oregon have also passed similar laws. This was just the most dramatic that we've seen because it specifically mentioned, and Tri-State made the mistake. They shouldn't have said retire Laramie River Station because they don't have the authority to do that. They're a minority owner in that. But so this was the one that really caught everybody's eyes because it specifically said it would have an impact on one power plant in particular.
And the plan for Laramie River is unit by unit, or is it a complete shutdown at a certain date?
Mr. Chairman, right now there is no plan for shutdown.
Oh, okay.
I mean, we have a
Good.
retirement plan, I guess, you know, that we had to submit for our air permits and all those permits, but it's not in the crosshairs anytime soon, Mr. Chairman.
Good. Okay, thank
Thank
you,
you.
Mr. Taylor. Thanks for joining us today. Please state your name or your alias, whichever you're operating under today.
Mr. Mr. Chairman, I'm not sure what to use today. Travis Deti with the Wyoming Mining Association, and I'll be very brief. We support this bill and appreciate the bill sponsor bringing it. And the state has, and this body has shown over this session, that we are all in to protect our coal industry and our coal resource. And we feel this just gives the governor the tools to do that. So we support the bill. And thank you for all your support.
Any questions of Mr. Deti? Any questions of Mr. Deti? Hearing none. Thank you, Mr. Deti.
Thank you, sir.
For your testimony. Anyone else like to speak from the audience? Anyone else like to speak in person from the audience? No. Is there anyone on the tube that would like to speak?
Yes, Mr. Chairman, you have Miss Shannon Anderson.
Shannon Anderson. Shannon, go ahead.
Okay, thank you, Mr. Chairman. Shannon Anderson on behalf of Powder River Basin Resource Council. And our organization is opposed to this bill, and especially the appropriation, because, Mr. Chairman, we're doing this backwards. We don't know if there is a cause of action yet or how strong it would be if there is one. And instead, we're putting a big sum of money into a fund just in case something comes up. We believe it would be better to let the professional, already compensated lawyers at the Attorney General's office to research potential actions, have them bring something forward to you, and then if additional funding is needed for outside counsel or litigation expenses, we can go from there. We're also concerned about the transparency on the spending and the lack of checks and balances within this bill. We know from previous litigation the state has done, it's really easy to run up billable hours and legal expenses without any measurable payback to the state. And what happens when the funds run dry? Will whatever litigation we have started end? We understand that there are reports due from the bill, but it will be hard to correct course if litigation is initiated. We ask that you vote against the bill to encourage the governor's office to come back when a case is ready to go forward so we can plan this out the right way. Even with the reduced appropriation, this is a significant amount of money and we need a thorough review before spending it. The Minnesota 8th Circuit case that was brought up, I would just note that it was based on a relatively unique set of facts. And it's worth noting there is conflicting law from other courts. The Dormant Commerce Clause part of that case was a minority opinion, and the majority opinion of the 8th Circuit decision was based on preemption concerns with the Federal Power Act. The Federal Power Act creates sensitive and complex federal state jurisdictional issues by giving FERC authority over interstate wholesale sales and transmission of electricity, while the states have authority over generation and distribution facilities, as well as retail rates. The laws in our neighboring Western states that have been mentioned today have been thoroughly reviewed as being compliant with this Federal Power Act because of this balance of jurisdiction and how states are expressly authorized by Congress to regulate power sources and retail sales of electricity within their borders. One thing to keep in mind, Mr. Chairman, is actually Wyoming has a generation standard now too. Last year, you passed House Bill 200, which requires a portion of power generated in Wyoming to be generated by coal with carbon capture. Can other states now sue us for that? As a state, we normally respect the rights of other states to make decisions within their borders, even if we disagree. And we ask that you exercise caution and discretion and ensure this litigation is really in the best interest of the state before the appropriation takes effect. Mr. Chairman, I will also note that if reliability is your main concern, it's worth noting that no coal plant is 100% reliable. All coal units have maintenance issues and events, and the Laramie River Station that was mentioned earlier is no exception. I recently did a public records request to the Department of Environmental Quality for outages at the Laramie River Station. And just in February, there were multiple outages, some for multiple days, and many of them were unplanned. That's just the reality of an aging coal plant. in the world that we find ourselves in. So it's really, I think, important to realize that the best reliable system of electricity is one that is balanced with multiple sources, can rely on balancing from other geographic areas, and really kind of draws in the grid from other sources and availability when we need it. So I would just point that out. Again, if reliability is your main concern about doing this litigation. And with that, Mr. Chairman, I'd be happy to answer any questions you may have.
Okay, thank you, Ms. Anderson. Any questions for Ms. Anderson? Any questions? Any questions? Hearing none. Thank you, Ms. Anderson, for your testimony. Thanks for being on the tube with us today.
Yeah, you bet. Thank you, Mr. Chairman.
Anyone else on the?
No, Mr. Chairman.
No? Okay, we'll close public testimony. And committee, what's your pleasure? Moved. Is it seconded? And seconded. Moved and seconded. Any discussion, any changes, deletions, additions? Yes. Senator Rothfuss.
Thanks, Mr. Chairman. I'm pretty confident in the end that I'm going to vote against the bill, even though I'm sympathetic to a lot of the concerns here, certainly. There are a few amendments I would suggest, but I just wanted to note that even with the proposed amendments, it's not going to make a difference on my vote. I want to make sure you know that. But I'd go over a couple of concepts and then I'll note why I'm concerned with the bill a little bit. The first is that the findings, I don't know that they would necessarily be of value on the Senate floor. Some of them are cold hard facts. Some of them are kind of subjective. And one concept, it'll probably be brought up by a tall senator from Natrona County, would be to delete those findings.
And that's all of section 1.
Yeah, exactly.
Yeah.
But again, it's all up to you. Another just thought, if I were planning to vote for the bill, I would also on page 4 eliminate the word impermissibly on line 14, actions that impermissibly impede Wyoming's ability. And again, I'd leave that up to all of you. The idea that you've predetermined that it's impermissible kind of limits the scope of the lawsuits that you would potentially bring. And if I were advocating for the bill, I'd want to get rid of that word. And then on page 5, the reporting requirement to minerals and JAC for the next 10 years, twice a year. I would suggest changing that language to by October 1st, 2021, and each year thereafter until October 1st, 2030. Because honestly, it's kind of make work more than once a year. Those are my suggestions. And again, my thoughts on the reason that I'm overall opposing the bill is we literally have an AG's office that does this. In fact, my phone buzzed indicating a tweet about a lawsuit the governor just filed a couple of hours ago using the AG's office and the funds that we already appropriate for that purpose. This is, I mean, we like to pass these bills because we kind of like to shake our fists now and then, but at the end of the day, we have everything we need. And this is just an appropriations request that if the AG's office needs more money, you just go in and you say, hey, we need more money, hire a couple more attorneys. And the appropriations committee talks about it, decides whether that's the case or not. So we do this already. And that's why I'm a no on the bill. Again, I was supportive of a lot of our efforts with the Millennium Bulk Terminal and all sorts of things over the years. I've tried to support those things, but I just don't know that we need to have a set aside appropriation of $500,000 to do it when we already have everything in place to do this. And if we want to throw, really, if you want to do this more, throw some FTEs at the AG's office and designate them. That's the way to do it, through the budget, and add 3 more attorneys in the AG's office, pay them salaries and say, do this, and it'll happen better. This is wide open, and I contemplated, probably anticipate external funds. The rate of work we would get if we were hiring out instead of hiring AG attorneys, I feel like we'd be spending about 2 to 3x the dollars on the same legal work, excuse me. So those are my concerns. And again, I would encourage, if you do want to pass the bill, to contemplate some of the suggested amendments I had, but I'll stop there and let the rest of the committee work.
The others? Yes, Senator Cooper.
Question on the amendment, on.
He's not making an amendment yet.
Okay.
He's just
On
telling us.
your
to do it.
discussion.
He's
Your
telling us to
your
do it.
suggestion on the proposed amendment, how's that? You were suggesting on page 5, section 3, a change in the date. What was that date change, please?
Mr. Chairman, it says beginning on October 1st, the language construction of by October 1st, 2021 is what we tend to prefer. So you get it at a Minerals Committee meeting and a JAC meeting at some point before that, if that's the intent. And there's nothing magical about October 1st.
Okay.
Pick any date you want. And then, and each year, instead of each 6 months, we typically receive annual reports unless there's some sort of prioritization. And since this is looking 10 years ahead, it seems like an annual report would be sufficient. That was just the thought I had.
Any other questions? Any other questions? Senator Cooper?
No.
Oh, okay. All right. And I agree with Senator Rothfuss. All of section 1 probably needs to be removed because it's findings. But I'd like to leave it in and take it to the floor with that on it so that the whole body hears it, and then we can take it out on the committee of the whole or the second reading, whatever we want to do. I do like that section 3, changing that to annual. There's no reason to have 6 months. My God, it's way too much, way too much. And I don't know about impermissibly. I don't know about that word, but I would make a motion to change on page 5, after line 9, after each, change it to each year thereafter. And so that we only get an annual report. Senator Cooper.
I like that motion, but should we add the word by in there as discussed? By October 1st?
I think that's a friendly amendment, and that's a second. I'm assuming that's a second.
Second.
Okay, all right. All right, so the amendment is beginning by October 1st to 2021 and each year thereafter until 2030.
I think you would want to strike beginning on.
Just strike beginning, yeah.
You guys are strikers, aren't you?
Sure.
You're striking beginning?
Yep.
On,
Just,
beginning on.
we already struck it. We have by in there.
Okay.
We just
By
have
October
the word by.
1st, 2021 and each year thereafter until October 1st.
Yes, sir.
Any other striking? Any other striking you boys are going to do? Okay,
So there was no motion on section 2, line 14 for that word?
no. No. Section 2, line 14.
The impermissibly?
Oh, no, no. No, we've got to study that some more.
Okay.
Those are big words. There's more than one syllable. We got to study that some more.
look it up.
Let's do some. So on the motion or the amendment is on page 9 to strike beginning and on and put by October 1st, 2021 and each year thereafter until October 1st, 2030, the governor is going to make a report to everybody.
I got that.
All in favor of the motion or the amendment, signify by saying aye.
Aye.
All opposed, same sign. That amendment carries. Any other amendments, any other striking you boys want to do?
All struck out, sir.
All struck out? Okay, well, let's call the roll then on this, Mike, please.
Okay. This is for House Bill 207. Senator Beitman,
Aye.
Senator Cooper,
Aye.
Senator Rothfuss,
No,
Senator Wasserberger,
Excused.
Chairman Anderson,
Aye.
House Bill 207, 3 ayes, 1 no, 1 excused.
House Bill 207 amended has passed the Senate Minerals Committee. That's all the bills come before us today. We have 2 bills for Friday. Is that correct? No, we didn't get any more. 166 and what was the other one? It just read in today, wouldn't it? Well, we'll get an announcement out. We'll get an announcement out so you know. All right. Senate Committee, Minerals Committee is adjourned. Thank you.